Welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys.
Hello and welcome to Navigating Consumer and Family Law Challenges, Insights from SoCal's trusted attorneys. I am your host, Kevin Rosenquist, and today I'm joined by Amanda Hill, a family law attorney who offers helpful, caring, and professional legal services and advice. And today we're going to discuss sole versus joint legal custody. Amanda, welcome back. Good to see you.
Hi, thanks for having me.
All right. So what role does the child's best interest play in legal custody decisions, and how does the court determine what's best for the child?
So when it comes to legal custody, the court is required to look at what would be best for the child in its best interest or in the children's best interest as to who should be making decisions about the health, safety, welfare, education of the children. Oftentimes, this is a very contested issue because one parent, after they are separated, believes that they can make those decisions better than the other, or sometimes it becomes a situation where one parent is not capable because they have substance abuse issues, or maybe they're in jail or they're in and out of rehab, whatever the case may be, to where the court finds it's appropriate that maybe one of the most stable parent needs to be making those decisions.
And can you explain the difference between sole legal custody and joint legal custody, and what factors influence the court's decision on which type to grant?
Yeah. So in general, the default, at least in California, is joint legal custody, meaning both parents need to be involved in the decision-making as it relates to the parenting and the decisions of how to raise the child, religion, healthcare treatments, where they should go to school, private versus public, things like that, and just general welfare. Should they be in soccer? Should they be in gymnastics? Things of that nature. And so in general, the rule of thumb is most of the time, unless there's something really extreme, the court is going to grant joint legal custody. Now, in some circumstances, the courts will do sole legal custody because one parent is completely MIA. They haven't been involved at all. And so it just makes sense for the parent that has been the stable parent to be listed as the sole legal custodial parent. And so they get to solely make those decisions regarding the child or the children. Sometimes there is a situation where the court will say, okay, I'm going to give joint legal custody, but because there's been such a long history of disputes between these parties as to some of the issues, so one of the examples is sometimes they'll argue over vaccinations, or they'll argue over private versus public school, or they're going to argue over, whether they have an issue with not taking the child to the doctors when they should. And in that situation, the courts may say, well, I don't think it quite rises to the level of stripping that one parent of their legal custody, but I think I'm going to give the more stable parent that has the history of showing good judgment and good decision-making what's called tiebreaker authority. And what that means is in the order, it's going to say, you have to talk about it. You guys have to discuss these issues. But if you guys reach an impasse in writing after 48 hours, you've discussed it and you just can't agree, that one parent is going to get the final tiebreaker authority to make the final decision. The key with that option, if that is ordered, is you have to make sure you have everything in writing to show proof you did discuss it with the other parent first. To address your question about what are the factors that the court looks at, it's many different factors, but it's going to be the history of involvement of both of the parents, who's taking them to the doctors and dentist appointments, who's taking them to school. Another big one is who's going to the parent-teacher conferences on a regular basis. There are many children out there that maybe they need extra help at school, or they have what's called an IEP or a 504 plan where they have special needs. Who's the parent that's always involved? Who's the point person that's meeting with the teachers and the therapists? So the courts were going to look at that. Now, also, of course, like I mentioned earlier, the courts are going to look at, is one of the parents, do they have a substance abuse issue, drugs, alcohol? Are they neglectful? The other big one is there a history of involvement with child welfare services or child protective services on either end? Because that's going to be a factor that the court's going to look at.
And when joint custody is awarded, is that always a 50-50 split?
So it's going to be one of the three options I just listed. If it's joint, it's only going to be the two parents. The only situation that I've seen where it's joint and it's more than just the two parents is when on a really extreme situation where there's a joinder of another family member, because because at some point, neither parent was fit to take care of the children. And so a grandparent or an aunt or an uncle have had to temporarily step in to provide guardianship of the children or to provide care of the children. And in that case, sometimes legal custody can be shared with those individuals. That's a very rare situation.
If joint custody is awarded, does that, because sometimes obviously like one parent gets the kids more of the time, the other parent just gets them every other weekend or something like that. Is that still considered joint custody, or is that sole custody with visitation or something?
Oh, you're talking about physical custody.
Physical, yeah.
So physical custody is completely different than legal custody.
Okay, gotcha.
Yeah. Legal custody is what rights do you have as to how you're going to parent and take care of and raise your child. Physical custody is who physically is taking care of the child and during what periods of time.
Okay, I gotcha. That makes more sense. So the joint custody is what we're taught for what we're talking about. It really is just about either both parents are have equal say in what happens with the child's life, and in sole, it's one parent has the ability to decide, and the other one doesn't legally have a say.
Correct.
Okay, gotcha. That was my bad on that one. I think I got him confused. Thank you for clarifying.
No, it's good. It's good because a lot of people don't know that distinction.
Yeah.
And it's really important to understand that distinction. I also think that what people don't understand is even if somebody is granted sole legal custody, and you know what, I forgot one. Another situation where there's sole legal custody is when there's a restraining order against one of the parents.
Yeah.
And even if the children are not included in the restraining order, then the protected parent gets sole legal custody because there's something in the California Family Code, it's Family Code 3044, that says that a parent that has been found a perpetrator of domestic violence cannot have joint legal custody unless the court has determined that they have overcome the presumption that they are not fit to be able to have joint legal custody. And then there's all these parameters of what they need to do for them to overcome that presumption. So in those situations, if somebody has a restraining order protecting them from the other parent, then they're going to have sole legal custody until that no longer exists or the other side has overcome the 3044 presumption. The thing that a lot of people forget, though, is even if you have sole legal custody, the vast majority of the time, you still have to allow for the other parent to have access to school records, medical records, so that they could see what's going on with the child and have access to that information. They just don't get to make the decisions about those issues.
And I know you said that the court will generally go, 50 joint custody unless there's some I don't know, issue that would prevent them from doing so. How often have you seen it where it's sole custody versus joint? Is joint way more common?
Yes, I would say 80% of the time, and that's just a rough estimate, it's going to be joint. Because again, the public policy when the courts have set this up and these laws up is to say that both parents, regardless of whether it's mother or father or two fathers, two mothers, whatever the situation may be, they shouldn't have an automatic right, one versus the other, based off of their roles, right? It should be, if they're going to be splitting up and splitting households, the default is going to be joint legal, joint physical custody. So that's kind of what the starting point is for the court. And then the court has the ability to, differentiate from that and go off of that and change that. But that's kind of the starting point. So you got to give the court the reasons why it shouldn't be joint. And there are reasons why, and there are valid reasons why a court would, go away from that. But you have to give them the reasons, and they have to be what the court would consider valid.
How does the court handle when the two parents, they just do not get along? Do they take that into consideration?
Yes, the court in general will take that into consideration. And when I have clients come to me and they're in those situations, I first assess whether it's a situation where can they even effectively co-parent? Have they taken co-parenting courses to where this is fixable? Or are we in a situation that it's so bad that they're probably going to have to what's called parallel parenting and just kind of do their own thing and have limited communication with each other? It's not an ideal situation, but sometimes situations get that bad. In those situations, you have to have written documentation and proof of the history of the discourse, of not reaching agreements, of one side showing that they're completely being unreasonable and just saying no to say no and not actually discussing it. And if you can show that documented history, that's a situation where you can go in and ask the court to modify joint legal custody and say, you know what, it's just not working out. And now my child's suffering because, for example, they need to have the surgery and this is what the doctor is recommending, but he just doesn't want to agree to me on anything. And so it's hurting my child. So I'm going to go into court and say, hey, at least as in regards to medical decisions, I need to make the final say. And so that's oftentimes one of the remedies that I see the court do is instead of stripping the other parent completely of their legal custodial rights, they'll maybe say, okay, I'm going to do a carve out and say, hey, clearly you guys can't reach an issue on medical issues, but I think, mom is showing me or dad is showing me that there's a letter from this doctor that says this child needs this surgery, for example. So this one individual parent, whoever it may be, needs to be making the final decision on medical related issues or educational related issues, whatever it may be.
Okay, so they'll step in and actually pinpoint certain areas where one parent gets to make those decisions. That's interesting. How granular does that get? Like if one parent wants their kid to play football and the other one says, no, it's too dangerous. Is that too trivial, or is that even something that you can go to the court with?
It's interesting. That is the specific one you just brought up because I've seen it litigated before.
Oh, really? Oh, cool.
But it was because, it was essentially a superstar athlete, 13, 14 years old. One parent was like, what about TBIs? What about the injuries? And like, I don't know if I want him to do, continue with this. And then the other parent's like, but he can get a scholarship and maybe he can, really make this a career. And then there's evidence presented to the court. And then the courts don't love that, right? They don't want to be spending their time dealing with issues like that.
Totally. I understand that. Yeah.
But if it becomes a really serious issue like that, sometimes the judges will step in and say, I'm going to make a decision on this. Again, they don't love it, but sometimes it'll happen. Or they'll say, you know what, you guys have to figure this out. And if you can't reach an agreement, then I guess your child's not going to participate in this activity. But in that situation, I often see the judge will kind of give a long talking to with both sides and essentially say, you really should work together, for the benefit of your child and figure this out, or else they're the ones that are only going to be the ones that suffer.
Right. Absolutely. Yeah. Especially if presumably the child really wants to play. Let's talk some do's and don'ts when it comes to, demonstrating the capability of handling joint custody. What are some common do's that you tell parents, to make sure that they're showing that they're capable of handling joint legal custody?
I always recommend, first and foremost, keep everything in writing. So there are applications now, which are awesome. And I always recommend one of them, for example, is called Talking Parents. There's Our Family Wizard. There's all these different portals, essentially, that you can utilize to keep all your communication solely in that portal with the other parent. And the nice part about using those apps is you can create different conversations. So one can be labeled medical appointments. One can be labeled before and after school programs. One can be labeled homework. One can be about vaccination, whatever it may be, and you can keep everything organized. So the first tip is always document everything. Even if you have a good parenting relationship with the other parent and you talk about it in person when you do a drop off or after school, make sure you then follow up and say, as we just chatted about, thanks for talking to me. This is what we've agreed on.
How about some don'ts? What do you tell people to avoid?
I always will tell my clients, think before you say anything. Think before you write anything.
Before you send that text.
Take a beat. Yeah, take a beat before you really send something, because anything can be used against you in the future. And you want to make sure that you're responding appropriately. And sometimes certain messages don't need a response either. Sometimes silence speaks volumes. Right? If it's a message that's just attacking the other person's parenting or attacking their character, that doesn't require a response. In fact, just save it, keep it, and if you need it later, you'll have that. But it's really not good to go back and forth if it's just not going anywhere. So that's a big don't. The other thing would be assuming that you guys are on the same page because you do have a good co-parenting relationship. But then maybe new relationships come in and then things might get awry. So always making sure and confirming, like, communication is key, and making sure like everything is agreed upon in advance. And also don't assume that the other parent is going to be readily available to make a decision or decide something right away. Now that you're in two separate households, you have to be considerate of their time and their schedules and if they're working. So they, be reasonable with what your expectations are too, as far as getting a response.
If for anyone listening who might be at the very beginning stages of a divorce and they're maybe worried about that piece, that legal custody, because they don't think that their soon to be former partner is really capable of having joint custody, how should they prepare for that conversation in a legal setting when that were to come up?
The best thing to do to prepare is, if one parent is really thinking that they don't believe the other or their soon to be ex-spouse is capable, is to go sit down and organize your thoughts as to what evidence do you have to support that claim?
Right.
Why do you feel that way? Jot down what your reasonings are, and then go, okay, based off of that, what evidence do I have, or what documentation do I have to prove that? Or what examples do I have to prove that? And sometimes, for example, it will be, well, I can go to the school and see all the times that I signed my child in and signed him out and he never did, or she never did. Or a parent can say, hey, I was always the one that took them to all the doctor's appointments. You can go and print out or log in and save copies of all the medical records showing who was the parent that took the child to all those appointments. So you really have to reflect on, is it in fact that I maybe am just not so happy with my ex-spouse? Or is it in fact really, are you looking at, I believe my child may suffer if they are allowed to participate in those decisions? Because that's really the big distinction, right, that the court is going to look at is, are they so incapable that, it could harm the child? And that's really what you have to think about and really pause and say, maybe if given the option, maybe they will step up to the plate. Who knows?
Mm-hmm. Yeah. And I think that's an important thing to keep in mind, right? It's about the kids. That's what you have to kind of keep in mind. It's about the kids, not your animosity towards your future ex.
Yeah. And I will add one more thing. A lot of people forget that when they're a married couple or partnership and they're living together, it's totally normal for one parent to take on a larger role in the rearing of the children, right? Because that's just what they've set up as their family unit. But when they split up, it's going to be that the child is going between two different households. So you have to know that maybe they were never put in that position before to have to make those decisions or care for the child in that way. But the court's going to assume that now that they're in two separate households, that unless there's something really bad to preclude them from having the ability to do that they're going to be given that chance to do that. And then it's essentially a probationary period. So if they're given the opportunity and they don't step up to the plate or they don't do it, you always have the opportunity to go to court and say, well, they were given joint legal custody, but clearly they didn't do what they were supposed to do, or they're ignoring me, or they're, not co-parenting. Then you can go back to court and say, I think it needs to be changed.
Well, great advice as always. And thank you for joining us on Navigating Consumer and Family Law Challenges, Insights from SoCal's Trusted Attorneys with Amanda Hill. To connect with Amanda and her firm, visit kandhlawgroup.com. And please like and subscribe to our channel and leave us a review. Amanda, great seeing you again. Thanks so much for your time.
Thank you. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.